Summary of TCC judgment. Hello, I am Jimmy Yang. I will do a series of videos to explain TCC judgment, that is the Taiwan Constitutional Court, the judgment of the Taiwan Constitutional Court. For example, today my video is about the 宪判 19, 2022. Okay, summary of TCC judgment 111, 宪判 19, 2022. The title is Case on the Suspension and the Resumption of the Coverage of National Health Insurance. Hand notes. In this judgment, the Taiwan Constitutional Court, TCC, declared Article 37, Paragraph 1, Subparagraph 2 of the Enforcement Rules of the National Health Insurance Act and Article 39, Paragraph 1, Subparagraph 2 of the same Act unconstitutional. The TCC ruled that the disputed provision regulating the suspension and resumption of national health insurance coverage without being specifically authorized by a statute consequently violated the principle under the Constitution. However, the TCC also ruled that imposing compulsory resumption and a 3-month duration before suspension of coverage upon returning citizens which are regulated in the disputed provision are of public interest and proportionate, thus not in violation of the principle of proportionality and the right to equality, equal protection under the Constitution. Background note: the petitioner resides abroad on a long-term basis and has applied for the suspension of national health insurance (NHI) coverage in accordance with the enforcement rule of the National Health Insurance Act, hereinafter the enforcement rules of NHI Act. However, when returning to Taiwan in 2015 and 16, the petitioner did not resume NHI coverage, which was required by the enforcement rules of the NHI Act, and was later ordered to pay up the premium by the National Health Insurance Administration, Minister of the Health and Welfare. As a result, the petitioner initiated an administrative litigation but has lost the case in the final court decision. The petitioner later filed for constitutional review in 2020, arguing that, first, the regulation applied by the final court decision, Article 37, Paragraph 1, Subparagraph 2, and Article 39, Paragraph 2 of the Enforcement Rules of the National Health Insurance Act has exceeded the authorization of the National Insurance Act. Second, the regulation's uniform application to all returning citizens regardless of the duration of their stay. And third, the regulation's differential treatment between government employees overseas and the general public has violated the principle of proportionality, causing undue restriction on people's right to property. Summary of a judgment holding. 1. The suspension and the resumption of national health insurance, hereinafter NHI, coverage affect the rights and the responsibility of the insured. They also involve important public interest. Accordingly, the specifics of the suspension and resumption of NHI coverage shall thereby be stipulated by law or regulation specifically authorized by a statute to conform to a requirement of the principle. Under Article 37, Paragraph 1, Subparagraph 2 of the Enforcement Rules of NHI Act, hereinafter, said Provision 1 and Article 39, Paragraph 1, Subparagraph 2 of the Enforcement Rules of NHI Act, hereinafter, said Provision 2. These two provisions violated the principle because they regulated the rights and the responsibility on the suspension and the resumption of NHI coverage without being specifically authorized by a statute. So the principle is that there shall be a specifically authorized responsibility to regulate the suspension and the resumption of NHI coverage, and the authorization shall be specifically authorized by a statute. And this is a constitutional principle. And the regulations, state regulations, violate this principle. That is, resumption and coverage shall be specifically authorized by a statute. The said provision 1 and 2 shall cease to be effective no later than 2 years after the pronouncement of this judgment. 2. Legal elements regarding the suspension and the resumption of NHI coverage set by the said provision 1 and 2 are not in conflict with the principle of proportionality enshrined in Article 23 of the Constitution. The right to manage one's health risk autonomously guaranteed by Article 22 of the Constitution and the right to property protected by Article 15 of the Constitution, nor does it violate the right to equality, equal protection enshrined in Article 7 of the Constitution. Reasoning. The people's right enumerated by the Constitution may be restricted by law, provided that it meets the requirements stipulated in Article 23 of the Constitution. In regard to the measure of policy concerning benefit to the people, if any significant matter is involved, it should be formulated in accordance with the law and the regulations specifically authorized by a statute. Admittedly, the NHI is a measure for providing the people with the medical care. However, considering that it is also a kind of compulsory social insurance, it is a compulsory social insurance, it is inevitable to restrict people's right to manage their own health risk autonomously, which is guaranteed by the Constitution in Article 22, e.g., the freedom to cope with the health risk through using one's own saving, purchasing commercial insurance, or be provided by family. The NHI also affects the people's right to property when imposing the responsibility of premium payment. Citizens who stay overseas for reasons such as working or studying abroad shall be allowed to suspend their NHI coverage. Whether they should be forced to resume their NHI coverage upon their temporary return, and if so, when they can reapply for suspension of coverage, also concerns the issue of compulsory insurance subscription. The aforementioned aspect inevitably affect people's right to manage their health risk autonomously guaranteed by Article 22 of the Constitution and the right to property enshrined in Article 15 of the Constitution. However, there is a massive amount of Taiwanese nationals that resides abroad on a long-term basis. Them paying premiums during their temporary return and using NHI resources will influence the fairness of the NHI system and the soundness of the state's finance as a whole, which both amount to significant matters in the public interest. Therefore, in accordance with the hierarchical principle demonstrated in J1 Interpretation number 443, the principle is that the issue applied to the matter regarding the rights and responsibility in NHI coverage, suspension, and resumption of a Taiwanese national overseas. That is to say, the substantial content of the above-mentioned matter shall be formulated based on law or regulations specifically authorized by a statute, and shall be in accordance with the principle of proportionality and the principle of equality enshrined in the Constitution in Article 23 and Article 7 of the Constitution. The said provision 1 and 2 are formulated under the authorization of Article 103 of the National Health Insurance Act, herein after the NHI Act, which stipulates that the competent authority shall prepare the enforcement rules of this Act. However, since this is an enabling provision in general terms and viewing comprehensively, the NHI Act did not mention a word regarding the matter on the suspension and the resumption of NHI coverage, even if we recognize leniently that this matter were under implied authorization by NHI Act. One cannot deduce from the NHI Act's legislative reason and its entirety any guideline or conceptual framework on how the competent authority shall prepare the enforcement rules on these matters, much less they can be foreseen by the general public. On the issue of whether the said provisions 1 and 2 violate the right to manage one's own health risk autonomously, right to property, and the right to equality and equal protection, considering that the NHI system is established for fulfilling the obligation entrusted by the Constitution, the legitimacy in restricting the people's freedom and right under this purpose is higher than the legitimacy in restricting people's right purely out of public interest under Article 23 of the Constitution. For this reason, the judiciary has to give more respect to this cause when exercising its judicial review on the aforementioned restrictions proportionality as a social policy involved allocating and facilitating the nation's resources. The political department has to take into account the overall political, economic, and social factors. Under the principle of separation of powers, it inherently wields a larger discretion in the formulation of regulation. Besides, the differential treatments deployed by the said Provision 1 and 2 does not implicate suspect classification. Therefore, the said restriction and the differential treatment shall be deemed in conformity with the principle of proportionality and the right to equality and equal protection if they serve the purposes of pursuing legitimate public interest, if their means are rationally related to such purpose. Per the said Provision 1 and 2, a person who stays overseas for over 6 months shall resume NHI coverage from the date of returning to Taiwan, but they can only reapply for suspension of coverage 3 months after they resume their NHI coverage. The purpose of said Provision 1 and 2 are to provide health care services during the temporary return of overseas citizens who suspended their NHI coverage while striking an equilibrium between addressing the purpose with moderation and avoiding the imbalance in responsibility of premium payment. The purpose of the said Provision 1 and 2 is undoubtedly legitimate public interest. Although the measure of compulsory resumption of coverage stipulated by the said Provision 2 apply uniformly to people returning temporarily to Taiwan from the date of their return, without distinguishing whether or not they actually use the NHI resources. Since the NHI system is a kind of compulsory social insurance, people have the duty to join and make premium payment once they are eligible to such insurance. Moreover, compulsory resumption of coverage upon their return only restore their insurance rather than imposing additional premium. Therefore, the said measure and the aforementioned purpose are rationally related. On the other hand, the measure of mandatory 3 months duration of resumption before reapplying for suspension of NHI coverage stipulated by the said provision, which implies a forced 3 months payment of premium, only poses a limited restriction on people's right to property. In addition, this measure also prevents the moral risk of people resuming and suspending NHI coverage with the purpose of returning to Taiwan temporarily just for its medical services. This measure undeniably safeguards the purpose of maintaining fairness in the NHI system and the soundness of the state finance. Consequently, this measure and its purpose are rationally related for the above-mentioned reason. The said provisions 1 and 2 do not contradict the principle of proportionality enshrined in Article 23 of the Constitution. In regards to the differential treatment in resumption and suspension of NHI coverage between the general public and the government employees overseas, along with their spouse and children, where the latter is exempted from application of said Provision 2 by Article 39, Paragraph 2 of the Enforcement Rules of NHI Act, it is for the purpose of government employees overseas to conduct their official duties smoothly, because they and their family dependents can not choose freely on the day of their temporary business return. It is a purpose of legitimate public interest, even though the general public is treated differently, excluding from this exemption. This differential treatment is rationally related to the purpose, thus not in contradiction with the right to equality and the equal protection enshrined in Article 7 of the Constitution. Thank you very much.